Well, hello everybody and welcome to 2024. I'm Joel Williams. This is Chase Elleby. We're personal injury attorneys at Williams Elleby. And today we want to talk about a few personal injury terms and demystify them so that everyone knows what they mean in the everyday world that we live in. Why don't you get us started, Chase?
Yeah, so the first word we're going to talk about is subrogation. So typically subrogation comes up in the health insurance context and also in the auto insurance context. And basically what subrogation means is it's your insurance company's right to seek reimbursement from the at-fault party's insurance or the at-fault party itself. So a quick example is, let's say you have a hospital bill that's $1,000, your health insurance company pays $300 of that hospital bill. Well, your health insurance company has a right to be reimbursed by the at-fault insurance company that may have caused the wreck for that money that they paid out. So when you hear the term subrogation, it's basically your insurance company's right to receive payment from the at-fault insurance company.
Yeah, or at least seek repayment, because sometimes they're not entitled to get that payment, but it's their right to seek it.
Right, it's kind of that old adage, it never hurts to ask. So,
that's right.
And they always ask.
All right, term number 2 is negligence. So when we speak of negligence, we're simply talking about a act that somebody else did that an ordinary person would not have done. So example would be running a red light. It's negligent to run a red light. It's negligent to leave an instrument in someone's body after surgery. It may be negligent to not clean up the floor and somebody falls on it. So negligence just refers to the fault of somebody else after they make a mistake and you get hurt.
Right, and the 4 elements of negligence that you might hear lawyers rattle off are duty. The person has to have a duty to act a certain way. They breached that duty, meaning they ran the red light, left something in. Causation, whatever they did caused injuries, and the last thing you have to prove is damages. So those are sort of the 4 buzzwords you hear when we refer to negligence. All right, so third we're going to talk about is apportionment. So apportionment is basically divvying up fault between parties who may be responsible for an injury. And to keep it super simple, let's say you have driver A who is driving down the road, leans over to pick up a water cup or something and swerves, hits another car which was speeding and shouldn't have been speeding, and then hits you and causes a wreck. Well, you might have a situation where you can apportion percentages of fault to each of those people involved. So the jury could say, I think driver A is 20% at fault, I think driver B is 60% at fault, and I think you might be 20% at fault yourself for driving a car you weren't supposed to be driving. So basically apportionment is when you can divvy up fault amongst different parties.
All right. Number 4 is proximate cause, and legal scholars have tried to define this word for centuries. I'm going to break it down real easy for you. Did this act cause this injury? And if it did, that's proximate causation. So did this act proximately cause these damages? Simple as that.
Yeah, super simple. But of course you could see the different scenarios that would pop out. You'd be like, well, did that really proximately cause those injuries? So that's why Joel said that legal scholars talk about it all the time, and there's classes on proximate cause. So, all right, the next one is negligence per se. Negligence per se is basically you're establishing negligence because there's a law on the books that has been broken. If you're speeding and you go past the speed limit and you get a traffic citation for speeding and you plead guilty to that citation, you have committed negligence per se, meaning you have in fact sped and caused negligence.
That's negligence as a matter of law.
That's right.
Yep. All right, the next term is ante litem. And when you hear somebody talk about an ante litem notice, it's usually in the context of getting ready to file a claim against a governmental entity, a city, a county, a state, the federal government. But usually when you file a claim against a government agency, you have to put them on notice prior to filing a lawsuit. If you don't do that, then you may not even be able to bring a lawsuit, and generally that notice is called an ante litem notice, and the requirements for an ante litem notice will vary from state to state. So if you have a claim against a government entity, make sure that you hire a lawyer that's familiar with those requirements in your state.
Next, we'll talk about the statute of limitations, and this is basically the defined time that you have to bring a claim. It's called statute of limitations because there's a statute or a code section under law that says how long you have to bring whatever the cause of action is that you're bringing. One simple statute of limitations is in Georgia, you have 2 years to bring a lawsuit against an at-fault driver for causing a wreck.
Yep. All right, number 8 is summary judgment. And summary judgment is most often encountered once you have filed a lawsuit, you're in litigation, and one side or the other files what we call a motion for summary judgment. And that is where one side is asking the court to rule in their favor as a matter of law. The most common scenario where you'll see this is when a defendant files a motion for summary judgment asking the court to throw the plaintiff's case out because of some area of the claim that the plaintiff has not presented evidence or carried its burden of proof, and so the defense will ask the court to throw it out before it gets to a jury. So that's summary judgment.
Next, we'll talk about total loss of your property damage, right? So if you get in a car wreck and your vehicle cannot be repaired or it's too costly to be repaired, that's what we refer to as a total loss. Now, different insurance companies have different thresholds, but typically it's anywhere between 75, 80, 85% of the value of the vehicle. So if it costs more than that to repair it, then the insurance company will deem it a total loss, and you'll basically get paid for the fair market value of that vehicle.
All right. And number 10, last but not least, is full coverage. Full coverage is a misnomer. If you hear somebody say they have full coverage, most of the time what they mean is they have whatever the state requires them to have to drive. And often, instead of full coverage, it's minimum coverage.
Right.
So there is no such thing as full coverage, legally speaking, even though your insurance may fully cover you for one particular wreck, it may not fully cover you for a different wreck if you cause more damages, or it may not cover you if someone else hits you and causes you damages that they're not fully insured for, or if they don't have enough insurance to cover your damages. So fully insured means nothing in the legal field, and if you hear somebody say it, you need to ask, well, what does that really mean? Because it means nothing under the law.
Right. I've had so many clients tell me that they have full coverage, and then I get the deck page, the declarations page, which shows the type of coverage they have, and it's almost always just the bare minimum, which is not full coverage. So.
All right, well, we hope this video has been helpful to you. Thanks for joining us for our first video of 2024. If it's been helpful to you, give us a thumbs up, subscribe to our channel. Otherwise, we will see you next week for our next personal injury video.